morning, everyone here from Brazil. Good afternoon for you, Jack. We are starting our second meeting of the year from the litigation committee from IBRAC. And as I have circulated the agenda for the meeting today, we will start this first part of the meeting with the interviewing Jack Williams. Jack is a barrister for Moncton Chambers in the UK. And in the second part of our meeting, we will stay here in this link and we will have our normal meeting for the committee to discuss a few issues that are pending, make some housekeeping discussions, okay? So I will start here. First of all, thanking you, Jack, for accepting our invitation to take part of our meeting and for your time too. I'm sure it will be a very interesting opportunity, at least for us, to hear a little bit about your experience in the UK with the competition litigation. You know, Brazil is starting, it's not that it's starting, but we don't have the expertise and the knowledge that the UK litigation has. So it for sure it will be very interesting for us. I have here Luis Eduardo, a colleague that will from IBRAC Junior. He's one of the coordinators of IBRAC Junior, and he will assist me in being the co-hosted of this event. Thank you, Luis Eduardo, for also accepting our invitation for all the IBRAC Junior's members to be part of the meeting.
Nice to meet you,
And
Jack.
also I want to thank Adriano Camargo, who is here. He made it to take part in the meeting. He was the one that suggested this topic to be discussed and put us in contact with Jack. So thank you very much, Adriano, for this. And to start the meeting, I give the ground to Jack. We would like to make a first question for you to tell us and share with us a little bit about your career path. We know that you are a barrister in the UK. The UK has a very different system from Brazil. You have this difference between barristers and solicitors, how they act before courts. And so we would like to know a little bit what you have to do to become a barrister, the kind of work that you do, the case you are used to deal with regarding competition litigation. If you could share a little bit with us, please.
Of course. Well, first of all, just for me to say it's a great privilege and honor to be speaking with you today. I'm particularly grateful for Adriano to put me in touch. It's a matter of great pride for me. I studied at Oxford University with Adriano on the Masters in Law competition. And it's a great surprise that both of us have ended up in competition law. And I'm delighted to see Adriano doing so well in his career. In terms of the pathway for my career to become a barrister, I studied law at the University of Cambridge for an undergraduate degree. So we specialised straight away after the school. One can study law for 3 years. And then I studied for a year in Oxford with Adriano, where I again studied law for a master's, and I specialised in particular in constitutional law and administrative law. So not economics or competition law. I've come to that afterwards. It's a real pleasure to have joined the competition law community, and I have very quickly learned economics. The division in the UK between barristers and solicitors is a unique one, but a vital one in our system, because you don't have to study law at university to become a lawyer in the United Kingdom. One can do a 1-year conversion course to become either a solicitor or a barrister. Now, what's the distinction, you ask, between a solicitor on the one hand and a barrister on the other? Well, solicitors are primarily those who engage with the administrative work and the client management. So if you think about preparing the paperwork and the bundles for the court hearings and helping the client manage the process with the lodging of pleadings and documents and the legal arguments, and they help draft the witness statements along with the clients. The barristers, however, tend not to do so much transactional work like the solicitors, but we are the supposed experts in a particular area of law. So we provide specialist advocacy within court. So we are the only ones who can stand up and argue the case in the court. The solicitors do not have the rights of audience, we call them, the privileges to do so in UK litigation. It's only barristers. And we also like to see ourselves as the specialists in the advisory work. So if it's not a transactional piece of work, which is routine management that a solicitor will conduct, they will instruct a barrister, somebody like myself, who has been doing the job for 10 years now. It's hard to believe. And we will give a specialist opinion or a specialist advice on what we think the law is and how that law applies to a specific circumstance. So really, the barrister is there to provide an independent second view, because as we all know, solicitors tend to have set clients they work with on a range of issues over a number of years. And sometimes it's hard, once you're in that long-term relationship, to either have the special knowledge for competition law if a dispute arises, or also it's hard to say no to your ongoing client, where having an independent external barrister helps provide a complete separation, so we can come and say yes or no, we disagree, because we have the expertise of working for a lot more clients on that area of law. So we have knowledge from a lot of cases that we can give to that one client.
Sorry. Perfect. Thank you for the explanation. And as a barrister, what kind of competition litigation you are used to work with?
Let me divide this answer into two, because it's a big question and an important one, probably between the differences in Brazil and the United Kingdom. So in the first half, if I take it from a substantive law perspective, and then the second half, the different types of procedure and the different sorts of litigation in the UK courts and in the EU courts. So let me begin with the substance of the law. I suspect this is remarkably similar to Brazil in that primarily it's either an abuse of dominance case, which is where there's one very large, usually corporate entity, which is unilaterally on its own abusing that market power, or allegedly abusing that market power, I should say, because often I work on the defense side. So it's always alleged abuse of dominance. And you can think of excessive pricing or market sharing agreements or exclusivity arrangements as that sort of abuse of dominance. That's a single entity with a very large market share or other powers so that consumers and customers can't act independently. The second type of claim is a cartel offence, which is between two or more competitors who are exchanging information, they're price fixing, they're sharing the market, and it's the conduct between two or more parties. And I suspect that's broadly the same for competition law around the world. What I suspect is different is the procedural elements of how those two core competition laws or antitrust laws are enforced and brought to courts. So let me talk about the different procedures. There are probably three different categories that I should set out for you. And this is where I think there will be differences. The first is that in the UK and the EU, we have a number of different regulators who investigate competition law infringements, both abuses of dominance and the cartel type offences that I've discussed. And after a very long investigation from the regulator, which has powers of investigation and dawn raids, whereby they go into the company's offices and premises and they collect materials and they interview company employees. After a very long process, they can reach a decision. And the decision will usually find an infringement of competition law plus impose penalties, so financial fines against an entity. And from there, although the company will have been engaging with the authority for a number of years and saying we are innocent, from there, the entity who has been found liable and has had an adverse decision taken against them, they can appeal that decision to the court. And we have a specialist tribunal or court in the United Kingdom, specifically and only for competition law disputes. And on that panel, the court is formed of a judge, an expert economist, and thirdly, a person from business. And that is the first instance court, whereby a company can appeal the regulator's decision and say this is just wrong or unfair, and they will try and quash or annul the decision in full, or seek to reduce the penalties or the fines. So that's the first type of dispute, which is very common, which is the public authority's decision is being appealed to the court. The second type of competition dispute is private party against private party. So it will be a competitor or a customer, for example, of the alleged dominant company, who is challenging that conduct without a regulator's opinion or a decision. So they can ask the court to establish the infringement. And instead of a penalty, the court will not impose a penalty in this situation. It's the customer or the competitor who will be asking for compensation, so damages for the loss that they, as an individual litigant, have suffered, not for the economy or effects as a whole, like it would be for a regulator's decision. Now, interestingly, in the United Kingdom, those private party actions can either be brought on what's called a standalone basis or a follow-on basis. Now, the follow-on basis is where there has already been a regulatory decision which has found the infringement. So they found the unlawful conduct, and then the private party will be able to use those findings, those binding findings, and say, okay, we would like compensation because we have suffered harm. So the case in that instance, the judge, the court, will not be looking at liability infringement. They will just be quantifying the effects, the impacts, and the quantum of loss, the amount of loss that that litigant has suffered. Whereas a standalone claim, by contrast, the private party has to establish the liability, the unlawfulness, as well as the impact and the quantum of loss that they have suffered. But it's interesting that the private party can do both. You don't need a regulator to be involved at all. So that was the second type. The third and final type is we have a new class action or collective proceedings regime whereby consumers, it tends to be the end user consumers, the person who might have paid £1 or £2 too much on a football shirt that the football shirt manufacturers in a cartel have alleged have all price fixed and inflated the price by a little bit amount, £1 or £2. And so we now have this regime where end consumers can come forwards in their millions. So millions of consumers can be represented by one person, one class representative, who has to be authorized by the court to bring this type of action. And so we have a certification process whereby this one person can bring a claim usually worth billions of pounds or euros, because all of those £1 or £2 sterling adds up into millions or billions of pounds worth of damage. And litigation funders fund these claims for the class representative. And the rationale behind this new regime is it's very expensive for individuals to pay for the lawyers, the expert economists, and go through a very lengthy court process when it's only worth £1 or £2, very low amounts of compensation on an individual basis. But it adds up on behalf of millions of consumers to be a lot of money. And so that's the idea behind this brand new procedure. And we have had 2 cases now in the United Kingdom that have got all the way through to trial. There have been lots and lots of certification hearings whereby the class representative is authorized as a suitable person to bring this claim on behalf of millions of people who may know nothing about the litigation. There is no necessary opt-in or sign-up process at the beginning. They may never know about this litigation being brought in their names, but they may collect some money right at the very end of the process. So they are the 3 main types of proceedings that I have witnessed. And as my final comment, I would say there has been a huge growth, a huge explosion of the third type, the class action collective proceedings. There are now probably about 20 or 30 of those cases, and it's the new trend in competition law in the United Kingdom, leading to a lot of additional work for us all.
Great, really interesting to hear that. I think in Brazil we have something quite similar, the three kinds of actions, but mainly the last one, I think we have what we call public action brought by the public prosecutor here in Brazil, but it is so bureaucratic and burdensome for the party that is, for us, it is still very difficult to see. You have one or another going on. But it's good to follow the trend, and we will want to follow up and see how this will develop in the UK, so we can follow the path here in Brazil. And now I'll pass the word to my colleague Luis.
Thank you.
Good morning, everyone. Thank you, Jack, for this general overview on the competition litigation in the UK. Just to give a context to my question, for started with the questions, one common ground for competition litigation in Brazil is the annulment lawsuit of CADE decisions. Here in Brazil, the annulment lawsuits focus more on procedural arguments and an attempt to demonstrate that the administrative procedure of CADE did not follow the due process of law or adversarial principles, and that should be annulled. On some cases, the merits of CADE's cartel investigations are also questioned. In case like of the documentary evidence used in the investigation was not appropriate, or even the reasoning used by CADE to achieve its decision. So my question is, what are the main reasons to ground an annulment lawsuit in the United Kingdom? And what kind of procedural arguments can be raised to try to annul a decision issued by the CMA?
Thank you. So I think there are a lot of similarities here from what you say, and therefore a number of lessons that might be applicable in Brazil. In the United Kingdom, there are both procedural and substantive grounds of appeal. In terms of the procedural grounds of appeal against the regulator's decision, they tend to focus on the rights of defence. So if in the process, the Competition Markets Authority, who is the regulator in the UK, known as the CMA, the Competition Markets Authority, if that authority and regulator has not disclosed evidence from complainants and questions of other market participants in the proceedings, so in the administrative phase leading up to the adverse decision, if they haven't disclosed those documents, or if they haven't given the opportunity for a right of response, or if the regulator has not itself thoroughly conducted an investigation. So if there are very obvious lines of inquiry that have been raised and the regulator has, we would say in English, closed their eyes to a particular line of argument or a potential defence, then there are these procedural arguments for the ultimate conclusion, the decision being quashed, annulled, even if substantively, in substance, it is good, because there hasn't been a due or fair process in leading up to that regulatory decision. So non-disclosure, not given an opportunity to respond, and not conducting a proper, fair process in lines with public law principles, constitutional law principles of good administration. So the right to be heard, for example. And that can lead to the annulment or quashing of the decision regardless. In substantive terms, the tribunal, the court in the UK, has ability to reach its own decision on the merits. So the court is not limited to the evidence that was before the regulator. New evidence can be put forwards by the undertaking who has had the adverse decision made against them to say that the decision is wrong. It does not have to just limit itself to evidence that was before the regulator. So there is the ability of the Competition Appeal Tribunal, the court, to reach its own conclusion on the merits with new evidence as well. So you often see the courts taking a full review of the decision, looking at all the evidence that was before the regulator, assessing whether the regulator has interpreted a factual or an economic document correctly and has applied it correctly, whether the regulator has missed or ignored a document or an argument, whether the regulator has made an error of law in the test that is being applied to that evidence, or whether the regulator has simply misunderstood and has not made the right decision. There is no element of deference to the regulator just because it is a regulator. There will be, for very complicated, detailed factual assessments, some deference, but the parties are entitled to put forward their own economic evidence from independent experts that question those assessments by the regulator, and the tribunal, the court, is entitled to, and indeed must, take that evidence into account in reaching its own conclusion. And at the end of the trial, the tribunal can decide whether to keep the regulator's decision, secondly, make its own decision, or thirdly, quash the decision, but send it back to the regulator to have another go. So there are all three options open to the tribunal, and they take these options routinely and regularly. I was part of a pharmaceutical appeal a year ago, where the court considered that the tribunal, the regulator's market definition was completely wrong. And rather than the court sending it back to the regulator to make corrections and reassess for itself what the correct market definition was, the tribunal itself defined the relevant market, which was somewhat surprising in some ways, because this is a very factual and economic and complicated questions, and some judges do not like to interfere with such questions, but the tribunal can and will do that. And I think the reason why that happens more commonly in the UK is because the tribunal has an economist and a business person as the judges, not just a legal high court judge. There is a panel of three. And so they are an expert panel who can form their own conclusions on the merits.
Thank you. Just one more question on the matter. But like the defendant can join like the procedure and the substantive in just one appeal, or has to file two different appeals?
No, it can do it in one notice of appeal, one application, and in fact it should just do the one application. And the reason for that is to streamline the process, by which I mean make the process as efficient and quick as possible. We have a very good judicial system to ensure that disputes are brought on and heard as quickly as possible. But even still, because, as I'm sure we will discuss, we have a very detailed disclosure process. This always takes 1 or 2 years for it to actually get to the trial, at least. But nonetheless, it tends to be very quick, and the court does not want a procedural application.
Okay.
The regulator then makes the same decision, and then there is an appeal on the merits again.
Thank you, Jack. I will go back to Juliana.
Yes, it's interesting the difference matter because, as you said, you have a very specialized tribunal that will analyze it and they can take this decision. Here in Brazil, it's one of the discussions we have a lot in our committee and in the antitrust community, that the same judge that will analyze a car accident will be the one that may, not a car accident because it's the federal court, but that it's analyzing something very completely different, is the same one that will analyze the annulment of a CAT decision that has so many economic factors involved. So it's interesting to see this difference and something that may actually work. But moving on here, we want to know a little bit about the case you have worked in. You have worked with the Intel case. It was an annulment of a 1 billion fine imposed by the European Commission, and also the Google case. And if you could share a little bit about it was 2 cases of abuse of dominant positions, as you said, that's more common for you to work. If you could share a little bit of these cases, and we want also to hear your thoughts on how do you think, and we know that the CMA has launched recently some investigation about abuse of dominance in digital markets, and so what are your thoughts and your view on the next steps of these investigations?
These are important questions, and they are important questions that are in the popular press in the United Kingdom at the moment. This is a big discussion point. Competition law has become sexy in the United Kingdom because you have a lot of big tech firms with very large penalties and fines being imposed on them. And it is something that everybody can understand and discuss. And obviously, at the moment, it's very political because you have the Trump administration and the potential trade war between the United States and the rest of the world, and big tech, big technology, and the American firms tend to be the defendants in a lot of these abuse of dominance cases with very large fines. So it's a very important and big question. So let me take that in steps. The first case that you mentioned there was the Intel case, and we managed to have a £1 billion fine quashed, completely annulled. And it's an interesting case study because it touches or discusses some of the points that we have been talking about in terms of the rights of defence, procedural fairness, and economic assessment. The case concerned Intel and its chips for computer, its CPUs, the things that we use in our laptops and computers every day without even understanding. And Intel offered loyalty discounts, so discounts to its customers for exclusivity arrangements, whereby essentially if the laptop manufacturers and the computer manufacturers used the Intel chip, the Intel CPU in their laptops and computers, and they bought more of these chips from Intel, then Intel would give them a discount. Now, if you asked the average person, does that sound like an abuse of dominance or harmful? They would probably say no, because discounts means lower prices. And lower prices tends to be good for consumers. The Commission, the European Commission, so the regulator for the EU, decided otherwise, and it had a very long, lengthy decision suggesting this was anti-competitive and that it foreclosed or excluded Intel's rival chip maker in the market because of these exclusive deals that Intel had with its customers. Now, the Commission had 150 pages of pure economic analysis on what is called the As Efficient Competitor Test, or the AEC test, which, to be very simple, essentially boils down to or equates to whether an efficient rival, an efficient competitor, could also have given those discounts and matched the price and competed with Intel. Because if an as efficient competitor can compete, that's all that competition law is trying to protect. Competition law is not there to protect less efficient competitors, because ultimately that doesn't help the internal market or produce economies of scale for consumers and cheaper prices. So it had 150 pages of this economic analysis. Now, that economic analysis was to be very blunt, dreadful. It was very poor quality. And there were lots of mathematical errors within this analysis. And the Commission said, well, we do not need this economic analysis. We don't need to look at the effects, the impact of the conduct and the impact on prices and whether other competitors could match the lower prices and the discounts. We don't need to look any of that because the mere fact of exclusive dealing, exclusive contracts whereby a dominant company enters into a contract with its customers for an exclusive arrangement where you only buy their product from them, that in and of itself is anti-competitive. The first instance court of the EU, the General Court, agreed with the Commission. Intel then appealed to the upper court, the ECJ, the European Court of Justice, and the Commission agreed with Intel. They agreed with us and said that's not the purpose of competition law, just to have a simple rule, a per se illegality, we would say, or you might call it an object infringement, a case whereby just by its very nature, it's anti-competitive. The court said, no, that's not how we do competition law in the EU. We always have to think about the effects and the impact on as efficient competitors in particular. There are some exceptions where the market has been foreclosed so much already that it's impossible for an as efficient competitor to ever emerge. And so the as efficient competitor test or benchmark does not apply, but that's an exception. And so that court then remitted it back, sent it back to the lower court. And we had a very large debate and analysis on the economics. We actually had the economists explain the errors and see what those errors meant for the decision. And in short, the court held that, well, you had 150 pages of analysis. It must have been important. And it's wrong. There are errors. We are going to just quash. Because in the EU courts, unlike the UK courts, the court does not reach its own decision. It does not rewrite a decision. Either the regulator's decision stands and is good, or it's quashed, it's wrong. And it's a simple binary choice in the EU. So that's why that case is important. For Google, this was another case, and it was this time a 1.5 billion euro case. So these are a lot of money, these cases. And again, we had success, but this time it was at the first instance, so before the General Court. And this again was to do with agreements to do with exclusivity. Essentially, when you went on a website, if Google powered the search results within that website, Google had contracts with the website publisher to show so many search results that were sourced from Google advertisements and people who had contracts with Google. So the Commission said this is an infringement because of its exclusivity. This time, the court said, when looking at the effects, the Commission failed in its investigative duties to analyze the effects, not because, like in Intel, it didn't do it at all, but because it didn't do it properly. So in particular, the Commission did not look at the duration of the exclusivity arrangements. And of course, tech moves very quickly. And if you have a very short contract of short duration, what's the problem? Because competitors can bid and win the competition or any procurement for the supply of that demand within a few months or within a few years. That's okay. The Commission needed to investigate. So it's a mix, Louise, between your question of procedural and substantive, which is why I think that's an interesting case. Now, finally, on your question about digital markets, the Commission, having suffered these very large two defeats, was not particularly happy. And it finds the abuse of dominance case law difficult because there are very clear rules on the investigations, the evidence, the detail of economics and the impact and effects that you need. So what it has done, it has come up with a new piece of legislation which came into force only last year, and it's called the Digital Markets Act. And rather than competition law, which is after the event and says whether conduct that has taken place in the past is lawful or not, and then you impose a massive fine, rather than that approach to enforcement, it is called ex ante or upfront, and it involves the European Commission in advance telling the company, the big tech company, whether its business practices are good or bad. And if the Commission thinks they are bad, the Commission will almost injunct or tell the entity what to do and how to rearrange their business. And if they do not comply with that, there will be a fine. So it's the Commission micromanaging and micro-regulating tech and how the products and services that we access should be offered in the first place. And it is trying to circumvent the very lengthy and long competition law investigations by doing it all more quickly up front. And there will now be challenges to this. So this week, there was a decision against Meta for Facebook and Instagram, the first decision. And I am representing Meta this week, challenging the Commission, which is saying that you cannot pay or consent for Facebook.
Yes, I saw both decisions yesterday, this week, the one against Meta and the one against Google as well, that was fined for not complying with the Digital Market Act. It's very interesting. We are following here. We have a specific committee within IBRAC to discuss the digital market. We are discussing here in Brazil if we should have or not ex ante legislation to deal with these new developments we are seeing in competition law. But we keep posted on the developments in the UK.
Thank you, Jack. Very interesting cases. We'll continue following how the things will go in Europe. But here, going back to Brazil, we would like to see your experience with damage claims. As Juliana said in the beginning of our webinar, Brazil is still nascent, crawling in cartel damage claims. Our judiciary branch is subject to time-consuming formalities, and we are not fully experienced to deal with this type of claims. Although we recently approved a new law, which amended the Brazilian antitrust law to encourage private enforcement claims. For instance, our new rules set forth double damages for cartel violations, extended the statute of limitations to 5 years, and created the exception for the leniency applicants, our few immunity recipient, to not be in a worse position than the other cartel members. As we know, UK has a well-established and robust system, likely one of the main jurisdictions alongside the Netherlands on this matter. So we would like to know what are the key elements that you consider essential for building a successful system for damage claims. This is my first question. And the second is, what are the main challenges faced when bringing a cartel damage claim before a UK court? And just to complement this last question, and what are the most common defense arguments that the defendants bring in this case?
So I think it's essential for a proper system of damages for a number of things. Firstly, I think disclosure obligations are vital in cartel proceedings in particular. And in the UK and the EU system, we have very strong rules that are known in advance on what should be disclosed. And it's very extensive. And I think that's important for claimants and a proper system for the judge to make the right decision, because without that information, by its very nature, cartel or collusion arrangements are secret. And nobody can necessarily know, and there is a different level of information that is available between the claimant and the defendant. So the defendant obviously holds all of the information and all of the disclosure and all of the documents. So I think it's essential to have obligations which are known in advance, so that the defendant will know, and also combine that with very clear rules on the preservation, the keeping of documents for a number of years. Because in cartel and collusion cases, it tends to be secret for a very long time. And so if there has not been a document retention policy or law, you tend over time to lose documents and people move jobs and people forget. So it's essential that you have both a strong discoverability or disclosure process combined with the preservation of documents in the first place. There is no point in just having a very strong disclosure process, especially in cartel cases, if the documents have all been destroyed and nobody is concerned or lost, and nobody is concerned about those documents coming up. The second point I would say is it's important for the judicial system to come up with a number of presumptions or rules for what happens in the absence of information. We have a very clear Court of Appeal authority in the United Kingdom that if there are no documents on a particular issue, and if the defendant refuses to provide any witnesses, contemporaneous, factual people who were involved, then the court is entitled to draw adverse inferences. So they can make certain assumptions against the party in question because of the absence of documents and because of the absence of witnesses. And that's helpful because it makes the process less complicated. It gives the judge less work because it makes it slightly easier if there are these legal presumptions. But it also encourages defendants who want to appeal against a decision and say, actually, the regulator got this wrong, there was no cartel. It encourages them to actually put forward witnesses who can then be cross-examined in court. So that's my second practical suggestion. My third and final practical suggestion in terms of what's essential for a successful system is proper code of conducts and rules of ethics for expert economists. In the United Kingdom, we have an adversarial system, by which I mean it's not the court that is investigating and sending out its own information requests and seeking the truth. Instead, the parties appoint their own experts who are supposed to be independent, but we all know that when they are appointed by a particular party, they are going to support that party's position. So it's vital for those experts to have the trust and confidence of the tribunal and clear ethical rules on independence when it comes to the calculation of damages. Because the key thing in most of these cases is how to quantify or estimate the loss. Most of the time there is a decision or it's obvious that there has been some conduct. And really the real battle is what have the impacts been and how much loss has been suffered. And you have to have a good system of well-qualified independent expert economists who have the court's confidence that when they are putting forward calculations and estimations or best guesses, they are doing so on a sensible and good basis. And so I think that's important. Very briefly on your second question, what do defendants argue? The common strategies are, I'm sure, the same. Delay and costs. Let's make this as complicated and lengthy as possible so that the claimant loses the will and settles or drops the litigation. And let's make it as costly as possible to make it as expensive to deter any claims in the first place or not make it worth it, because it will be take a lot of time, a lot of money. And so there are usually procedural skirmishes about when the trial should be listed and the content of that trial. And the UK court over the last 2 years has been trying new strategies and experimenting with new ways to divide up cases. For some cases, it makes sense to have what we call a split trial. So divide up and we just look at certain issues only. So if there is a procedural argument, limitation or time limits, or something about the market definition, let's do that first because it could save us lots and lots of money if there is no valid claim in the first place or the market definition is so wrong. Why are we spending so much time and money doing procedural arguments, market definition, abuse, and quantum all in one trial? So sometimes they will divide up the issues and so they can get certain topics on quickly. In other cases, it works in the opposite direction and it makes sense based on the facts of each case to do it all at once, because the more trials you have, the more judgments you have, and the longer that becomes. So it really depends on a preliminary assessment of the merits. If it looks already so obvious there is something interesting or wrong on market definition or procedure, they may be heard first.
I have one follow-up question regarding damage claims. When you are talking in the beginning of these questions about the need to prove or not the damage, what's the weight that the courts give to a CMA decision in terms of proving that the damage was caused, not the damage itself, but that the cartel existed or the abuse of dominance existed? And if this decision is being challenged in the courts, how in the damage claims this is considered?
Yeah, so it's considered binding, and it's binding on the tribunal and it's binding on the parties if it's not challenged. And there are deadlines. So if the deadline passes, it's binding. And there is a very careful process for which paragraphs or recitals or sections within a decision are necessary to support the infringement finding. And they have to be necessary rather than just, we would call it in English obiter dicta, but non-binding guidance or just observations by the regulator. So there is a careful interpretation analysis which is done first. But after that, it is binding. The court cannot open it up. Your question, though, becomes more interesting and complicated once there is an appeal against the regulator's decision. What happens in the follow-on damages claim? The damages claim tends to be stayed, by which I mean delayed and postponed. It's frozen in time until after the appeal. Usually that, because it makes sense. Otherwise, the private litigant will have to establish liability as well. Now, the regulator will sometimes talk about anti-competitive effects, but it tends to do so on a broad economy-wide basis. And so they are taken into account. But in damages actions, we have clear rules on causation of loss for the individual litigant. So there will have to be disclosure from that litigant to prove that actually they did suffer. You cannot just rely upon the finding of infringement. And I think this is a good opportunity to answer the question that's been asked in the Q&A chat box about if there is a settlement decision rather than a regulator's decision without an admission of guilt, would it still be a follow-on action or would it be standalone? Now, we have a saying in English called "the devil is always in the detail," which means that it's a case-by-case assessment and very factual. But as a broad rule of thumb, an estimate, usually if there's no admission of guilt, then there is no binding infringement decision, and so it has to be proven all over again. It's a standalone claim. It's not a follow-on claim. If, however, there has been a settlement decision and it's clear that a fine has been imposed, then that will become relevant evidence in the case and can be relied upon. But it's a complicated question.
Yes, for sure it is. And just when you were answering, you also said in the beginning about disclosing of the facts. Here in Brazil, we have one of the resolutions from CADE that the documents brought in the leniency agreement and in the settlement agreements, they are totally confidential even after the end of the proceeding. So if a party want to bring a damage claim, it should be based only on CADE's decisions, which is not as binding as is in the UK and the European Commission, but it's what we call prima facie evidence that the cartel existed and the damage is caused. I think the difference here is that the other party can try somehow the defendant can try to somehow prove that the cartel doesn't exist. There is some space for it before in a damage claim here in Brazil. Yeah. We want to know a little bit about this disclosure of documents, mainly regarding to leniency agreements and settlement agreements, if they are made available, even thinking here, if you have a leniency that is international, both in the UK, European Commission, that somehow it's also a leniency in Brazil, and that so if the parties may have access to other jurisdictions to these documents to bring a claim here in Brazil.
So we have very broad disclosure obligations, which claimants see as a real merit of bringing international litigation in the United Kingdom. So that means that we have an access to the file process. So if there has been a decision that's reached by a regulator, that regulator will have conducted an investigation over 2, 3, 4 years. And there is a default expectation that the access to file documents will be disclosed subject to third-party confidentiality material and also leniency and settlement material, which is privileged as well. So there are exclusions and exceptions, but you will get to see some of that material and leniency and settlement, but not all of it, because some of it is understandably sensitive. But we have a process for confidentiality clubs or confidentiality rings, whereby the lawyers and maybe one internal person will sign a confidentiality undertaking and give the court additional protection, whereby they, the small club, can see even confidential material. And we have a very well-established process for access to the file. It's a default, it's a quick, obvious repository or pool of documentation that should be easy to get and quick to get, and the courts order it routinely to be provided, any documents, as I say, subject to the confidentiality of third parties and the notification rules. But yes, that will be documents within the disclosure and discovery, which is ordered very early in the litigation proceedings. In addition to that material, there will also be disclosure sought by the parties. And I need to reiterate again that in the UK, we don't have an inquisitorial role for the courts. So this is not court-led. None of this is court-led. It's all party-led. So the parties will make a disclosure application and they will list the documents they want. And only if there is a dispute will the court then rule upon it. So it isn't the court issuing its own requests for information or the court of its own motion ordering disclosure. Because it's adversarial, the court acts like an umpire or a referee between the parties. And of course, there are expectations and there are rules of what should and should not be disclosed. And there are conventions and what's normal, so that the parties will know what the likely answer is from the court, or at least the philosophy and the principles of the court. But otherwise, it's party to party. and only if there is a dispute between the parties will the court say yes or no to those disclosure requests. But we do have very stringent and very strict rules on broad documentation. And as I said earlier, there are adverse inferences or risks of adverse inferences. One of my clients, it has been reported publicly, Google, to give you an example, has allegedly deleted certain chats and certain instant messages. And the US courts, at least, have drawn adverse reactions and inferences from that disclosure. And that will be a debate, no doubt, in future and ongoing litigation in the UK and EU, what that means and the impact of that if it's proven true. But it just demonstrates the very strictness of the disclosure rules and the impact it can have at the substantive trial in the EU and the UK because of adverse inferences. If the court thinks that a disclosure obligation has not been met, it treats that very seriously.
Jack, before we move on, we had set for a 1 hour conversation, but it's already gone. Do you have 15, 20 more minutes? Just we have 2 more questions for you, if it's okay.
Of course, yes, I can do up to 15 if that's okay.
15 is perfect. Okay.
I have probably spoken for too long, so please tell me to keep my answers shorter.
No, don't worry. I think we can make the damage claim, damage question.
Yeah, we separate one question about calculating damages because, like, we know that probably is the most challenging aspect of a damage claim is like calculating the damages, and here in Brazil, our legislation does not allow for punitive or hypothetical damages. So figuring out how much damage cartels cause is quite tricky.
Yes, of course. We have.
So how does the court determine the amount of the damages awarded and what factors are considered in these calculations?
So here I have in mind the private party litigation because obviously there would have been a penalty or a fine for the regulator, and the court has separate rules for when reducing that penalty based on the duration, the gravity, the seriousness, whether a party has repeated the conduct. But in private damages claims, we have what is called the broad axe in the United Kingdom. Now, the broad axe, so if you imagine a blunt axe that's being held by the judge, essentially, like a nutcracker, they take a simple approach to damages. They recognize that damages are very complicated. One can never be really, really precise, and one doesn't want to see undercompensation. So we have this principle of the broad axe, meaning that the judge is able to wield the broad axe and say roughly or approximately these are the damages that can be awarded. It doesn't matter if it's exactly precise, so long as it's not irrational or really far reached. Now, the way the court determines the damages is it always has both parties presenting expert reports and calculations for what the damages should be. And there is cross-examination by the parties and also by the court asking questions in live court, in live proceedings. They are cross-examined on their calculations, on their methodology, and how they have reached a particular number and why. Now, broadly, each case will depend on its own facts as ever. But broadly, we take an approach of we imagine a counterfactual world in which there was no infringing conduct. So we imagine remove all the unlawfulness, and we like to ask ourselves the counterfactual question. So the contrary to the facts, what could have hypothetically happened in that pretend world without the damage, without the unlawful conduct? And that involves, as I've said, exploring with the economists what happened, and also with the factual witnesses what they would or would not have done. Now, that obviously becomes very contested, and the economists have to use a number of different economic tools to calculate or estimate the likely behavior. Now, broadly speaking, the court operates on a profit maximizing theory. So it assumes that corporate entities are rational and that they would act to make as much money as they lawfully could. And it builds up from these assumptions, and it builds up from the factual witnesses, what they think is credible would have happened, and it makes a broad assessment. We like to say in the round, taking into account everything together in the round, and it will usually go down the middle. You'll have the claimant expert and the defendant expert, and usually it will be somewhere in the middle.
And one last question. We have been seeing that the UK and the Netherlands have become two forum shoppings for damage claims.
Yeah.
We have claims from Brazil that are being brought in the UK. You have the Orange Cartel ones, for example. You have the one from the disaster in Mariana. I don't know if you heard about it. But why do you think that's happening? What are the positive sides of the UK system that it's making it become one of the reference in damage claims?
Well, I think disclosure is attractive, as I've mentioned. I think the very long experience of the UK judges for competition law claims, plus the fact there are sometimes economists, helps as well, because I think clients can be more confident that there is a long established system with long established rules that everybody knows and can apply, and that creates some certainty. And I think that helps a lot, disclosure and expertise. I suspect the procedural mechanics might also help in that it may be quicker in some ways. But I think it's fair to say, there are also some potential risks or downsides, because you will be asking the court sometimes to apply foreign law. And that tends to mean that it needs an expert witness, which is probably fantastic for all of the advocates and lawyers on this call, because you could be instructed by a party to provide an opinion to the court on the law. So the question of law is treated as a question of foreign law, is treated as a question of fact, whereby it's a battle of experts. So there will be parties will adduce or procure witness evidence reports from Brazilian lawyers, like as yourself, to inform it of what the law is or is not. And that's probably good business for some of you, because you will write a report and you will then write a reply report to the other side. But the danger is you will be cross-examined by somebody like me in a UK court in London on your opinion, possibly, if there are any contestable points. But that might be fun. That might be something you look forward to rather than dread, which is it. We all have our own interests. But I think what makes the UK unique at the moment is that since we have left the European Union after Brexit, we have the benefits of two worlds. We have the benefit that we have all of the past EU jurisprudence, the past case law, and the rules from our experience with the EU competition law. But we also have the flexibility, because any new cases, the UK judges have their own autonomy. So whilst they are likely to follow the EU precedent, there is still some room for creative new arguments, which some clients may like and benefit from. But I should say that I was part of a case last year, which was a cartel case about car parts, and one of the alleged infringements was alleged to have concerned Brazilian sales in the Brazilian territories, and the UK High Court, where most of the foreign actions go, which is just a one judge case, no expert economist. The judge said that the UK was not the most convenient or natural forum for the dispute, and so it was struck out on what's called forum non conveniens. So the forum isn't convenient grounds, and essentially that's all to do with practicalities. So the language of the underlying documents, if they are not likely to all be in English, that will lead to it being a very complicated trial. If the witnesses and the experts cannot write and speak in English, it's unlikely to be a very convenient forum to hear it in England. And where are people located? So there are now new cases happening where the UK, for the first time post-Brexit, is determining its own role in the international plane and how many international cases it can and wants to hear. And so you do have to satisfy the court that it's the convenient and logical place. But if you have choice of law or applicable law clauses in contracts, and if you have jurisdiction clauses that regardless of the applicable law that you want it heard in England, the court will respect those types of arguments. But they are one factor that may or may not lead to the other side disputing the UK as the best forum for the dispute. But perhaps I'm biased. I think the UK is a good jurisdiction for these sorts of disputes.
No, great. And just a quick question, but the average time of a damage claim in the UK, how long do you estimate it?
At least a couple of years, probably 2-3 years. But
That's very short for us.
Yeah, okay. But this, of course, follows probably a few years of the company being investigated by the regulators, and then you have litigation on top. So I wouldn't describe it as quick. It's not as quick as the commercial cases in the UK courts. It's longer, but we are trying to be as quick as possible. It's quicker than the EU courts. Other member states and the EU central courts can take 6 years for these big cases. And obviously, I am assuming a very large case, like most of these cases are nowadays. Smaller cases, we have specific procedural rules that can be brought on within a year, but they would have to be very small.
I think looking from the Brazilian perspective, this is one of the attractives, because here in Brazil, we estimate around 15 to 20 years a damage claim to be through its whole path, so it's something very interesting. Let me see, I want to move to the UK, Bruno Maggi said. It's our dream, Bruno. Yes, indeed.
And I would like to move to Brazil for the sun, so we can swap.
We can exchange. We will go there for the damage claim and we come here for the beach.
That sounds good.
So, Jack, I don't have words to thank you for this spectacular chat we had about the litigation in the UK. It was very valuable for us. We had so many insights for what you said here that we could apply and make the Brazilian situation much faster, much efficient, And but it was really good to have this comparative view for us. So just want to thank you again for your time, for sharing your experience. It was really, really important and valuable for our committee. On the name of the committee and everyone that was here in this meeting, the IBRAC Junior as well. Just want to thank them for being part as well. I think for them, they are like beginning their journey in law, in competition matters. This was also very valuable information. So thank you again. And if you need anything from Brazil, we are at your disposal to help you, whatever you need.
Thank you. And likewise, it's been a real pleasure. Thank you for organizing it so efficiently. We didn't take years to organize it. So thank you very much. It was very efficient.
Thank you. Thank you for the master class.
Thank you. Bye-bye. Enjoy.